This is not speculation. This is not a political rumor. And it is definitely not just another exaggerated headline. In the past few hours, a judicial decision has placed Donald Trump at the center of a crisis that has moved beyond the legal sphere and is now directly pressuring the American political system. While most people reacted only to the headline, I went straight to the substance of the ruling. I read what is written and, more importantly, what is implied. And what appears there completely changes the outlook for the coming days. Because this decision is not just about one man. It establishes a clear boundary for how far power can go when the state decides to act against structures that, for years, seemed untouchable. What happened was not a warning. It was not a political message. It was a direct judicial order with immediate effect. A judge ordered the seizure of assets linked to Trump, breaking a long-standing pattern of delays, endless appeals, and legal shields that had always allowed time to work in his favor. This time was not granted. And that changes everything. Trump has faced investigations before. He has dealt with civil, criminal, and administrative cases. But there is a fundamental difference now. The focus has shifted away from the individual and toward the system. The court did not examine a single isolated act. It examined patterns. It examined structures. It examined how assets were valued, transferred, protected, and reorganized over time. And the conclusion was clear. This is not about occasional error. It is about an operational model. When a judge uses this kind of language, they are not merely resolving a case. They are opening the door to cascading actions. Immediate asset seizure is not symbolic. It means freezing. It means intervention. It means loss of direct control over strategic assets. And most importantly, it means real risk. Risk for financial partners, risk for institutions that extended credit, risk for contracts dependent on asset guarantees. No large business structure operates in isolation. Everything is interconnected. When one point gives way, others are tested. And the market understood this instantly. In the hours following the decision, institutions began reassessing exposure and risk tied directly or indirectly to the Trump brand. Not out of ideology, but calculation. Markets do not react to speeches. They react to legal risk. And that risk has increased. Another detail stood out: the silence. Normally, decisions like this trigger a flood of public statements. This time, figures who once defended Trump automatically chose caution. And in politics, caution is a language of its own. When allies avoid comment, it is not due to lack of opinion. It is fear of being tied to something that could escalate rapidly. Trump noticed this. The tone of his public reaction shifted. Less celebration, more direct attacks on institutions. This pattern is familiar. When a problem is manageable, he sells it as victory. When it slips out of control, he tries to delegitimize its source. But something is different now. Narrative does not override a judicial order with immediate effect. And that creates a real political problem. Trump built his image on strength, control, and dominance of the situation. A judicial seizure strikes at the very core of that image. And in an election cycle, image is capital. Each decision like this weakens the perception of invulnerability. And that affects donors, allies, and undecided voters. What we are witnessing is not the end of a process. It is the beginning of a phase in which every move carries real cost, financial, legal, and political. And that is exactly what makes the coming days decisive. The impact of this decision does not remain confined to the court that issued it. It spreads because it creates a new reference point for other institutions watching closely. When one judge breaks a pattern and acts decisively, others recalibrate their own limits. That is how precedents form in practice. Prosecutors, regulators, and tax authorities observe moves like this carefully, not to copy them outright, but to understand the space that is opened. And when that space appears, it tends to be filled. This is the point many people miss. The seizure is not merely a consequence. It is a signal that institutional tolerance has narrowed and that the cost of prolonging disputes has increased. From here on, the game changes. Because each new action stops being evaluated in isolation and begins to be seen as part of a larger pattern. Appeals that once bought time now risk accelerating responses. Legal maneuvers that once acted as buffers are now interpreted as organized resistance. And organized resistance has a price. This also explains the behavior behind the scenes in politics. When decisions begin producing tangible effects, freezes, contract reviews, reassessment of guarantees, the conversation shifts. Electoral strategies start factoring in short-term legal risk. Donors calculate exposure. Allies weigh the cost of association. That is why the silence matters so much. In previous cycles, legal crises were converted into political fuel. This time, caution suggests that the cost may outweigh the benefit. Defending a position publicly while the situation may still worsen is betting against the clock, and the clock is no longer on the same side. The scenario unfolding has three layers. The first is legal. The seizure order opens the door to further enforcement actions and deeper scrutiny of asset structures. Even if appeals are filed, the mere fact that assets are under review alters the balance of power. The second is financial. Institutions do not wait for final rulings. They anticipate. They reassess risk, adjust terms, shorten timelines. This creates constant, silent, effective pressure. The third is political. In an election year, every development stops being just a fact and becomes a narrative test. But narratives do not sustain contracts. They do not release assets. They do not halt administrative action. And that is what makes this moment especially fragile. There is also a less visible, but equally significant effect: institutional behavior change. When a decision proves that tough measures are possible, the incentive to avoid them diminishes. Agencies act with greater confidence. Inertia gives way to action. This cascading effect does not happen overnight, but it always begins the same way, with a clear, enforceable decision that carries immediate impact. That is why the coming weeks matter so much. If new measures emerge quickly, the interpretation will be that the system has entered corrective mode. If there is a prolonged pause, the reading will be strategic containment. In either case, the board has already shifted. For Trump, this means operating under new constraints. Every statement, every legal maneuver, every political choice will now be interpreted within this new context. There is no longer room to treat decisions as passing noise. For the political environment, it means that the cost of polarization may rise. Deep legal crises are not resolved by rhetoric alone. They demand time, resources, and concessions carry political cost. What we are witnessing is not a conclusion, it is a transition. A transition in which old protections lose effectiveness and new rules begin to assert themselves, even if they are not yet fully defined. And that is precisely why this case will continue to generate consequences. Every step will be analyzed, every reaction measured, every silence interpreted. In moments like this, what is not said weighs as heavily as what is announced. The asset seizure does not close a chapter. It opens a phase in which the system tests its own limits and observes who can adapt. Some will, others will not. What comes next will depend less on rhetoric and more on the ability to absorb impact. And that ability is being tested now, in real time. One thing is certain: the period of comfort is over. And when that happens, consequences stop being abstract and become concrete. That is where we are.